hearing for claim CFI 090-2023 brought by the Registrar of the DIFC Courts against Mr. Shaun Morgan, who is self-represented, and Franklin Morgan Legal Advisory, represented by Mr. Abeid Bintuk Al-Mari.
Thank you. And Aisha, you're representing the Registrar? Yes.
That's correct.
All right, thank you. All right, well, Aisha, over to you.
So to start off with, Justice Martin, to recap the main points that were set out in my statement that was brought in December 2023. This is an application brought to the court by the Registrar of the DIFC Courts in accordance with Part G of the DIFC Courts Mandatory Code of Conduct in the year 2019. Part G sets out the relevance of the orders that the registrar is seeking today, which is that a practitioner who has been sentenced to a term of imprisonment in Dubai or elsewhere can be suspended from exercising his rights or terminated from being a practitioner, provided that a judge of the DIFC courts is satisfied that the conditions have been met. To not go through the entire statement, the main points that we have set out in part of our statement is that we are of the view that Mr. Morgan was found to be, was imprisoned in the United States, and there were several sources that cited that Mr. Morgan has previously pleaded guilty and was convicted for serving a prison term for fraud in Switzerland and in the United States. In addition to Mr. Morgan's imprisonment, when at the point of time when concerns were being raised by practitioners who are registered with the DIFC courts, we began an investigation into Mr. Morgan's documents and the firm's documents as part of that were submitted to the court in order for them to become registered to practice in the DIFC courts. In submitting those documents to our document services verification provider, we came to know that all the documents that were submitted on behalf of Mr. Morgan were found to have a high degree of document tampering. Since then, we have also been in contact with various, I would say, officials in each of these certificates or the jurisdictions from which Mr. Morgan's certificates seem to have come from. We have been told that there is no individual named Shaun Gregory Morgan who is a registered practitioner or is registered to practice in the state of Maryland or New York or the District of Columbia. It is for this reason we have commenced these proceedings. As of today's date, the registrar is of the view that no sufficient evidence has been provided by Mr. Morgan in order to refute these claims that are being brought against him. In regards to the registrar's claim against the second defendant, the registrar takes the view that given that the second defendant has provided these fraudulent documents on behalf of the first defendant, the second defendant should not be permitted to continue their registration as a firm that is licensed to represent litigants before the DIFC courts. That is, Your Honor, in a nutshell, the registrar's claim, unless there's anything in specific that you would like me to take you through.
No, just so that I'm clear, so the claim is brought against Mr. Morgan, firstly, pursuant to Article 40 of the Code of Conduct in relation to previous imprisonment, and secondly, and in the alternative, pursuant to Article 38, which relates to general breaches of the Code of Conduct, those breaches lying in making application for registration as a practitioner when not qualified to do so, and in submitting various forged or fraudulent documents in support of that application. And in the case of the application against the second defendant, it's pursuant to Article 38 of the Code on the basis that as a result of submitting fraudulent documents to the court in relation to Mr. Morgan's entitlement to practice, that is also a breach of the code. Is that the case in a nutshell?
That is correct.
All right, thank you. All right. Is there anything else? You rely upon the documents that are on the court file?
That is correct, Your Honour.
Yes, all right. All right, Mr. Morgan, over to you.
Thank you, Your Honour.
Sorry, I'm just looking for some notes. That's all right. Yes.
No problem.
All right, proceed,
No problem,
please.
Your Honour. Yes, I have already in communication with the Registrar and the DIFC courts consented to their removal. I make no comment to their investigations, which are, for my purpose, nothing more than internet searches. And in my very brief submission to the court, I made reference that the internet is a very dangerous thing. And the registrar in her own right has said that, well, we're not 100% sure, but we believe. And in making such a serious allegation, one should be 100% sure. And throughout the registration process, the DIFC court registration team had every opportunity to deny registration, approve it. And Your Honour would be very much aware that it's not a basic process. There is a very, very procedural process to become a practitioner before the DIFC courts. Now, the only thing other than saying, Your Honour, with the greatest respect to the integrity of the court, I'm more than prepared to consent to the registrar's order, and I have given that in writing, that I wish not to re-register or be reinstated to the DIFC courts. The only comment I will make is that in my belief that most of the time you're brought before the bar or a committee alleging a conduct which was not becoming of a registered attorney, lawyer, solicitor, barrister. Such complaints are usually brought by a presiding judge or by your clients, whom would be unhappy with the representation they've given. That's not the case here. As the Madam Registrar has been very clear in articulating, this was brought by other law firms for whatever purposes are using the registrar to perhaps stop proceedings in the DIFC court. Now, I don't wish to prejudice the clients and their right to legitimate claims before the courts. So in furthering the overriding objective of the court, Article 1.6, I am more than happy to consent and given it in writing that I do not wish to seek reinstatement. And I will leave it to my esteemed colleague, who I have the utmost respect for, Mr. Obaid Al-Mari, as to why I feel that the singling out of his firm and prejudicing the clients of his firm who have made no complaints about their representation before the DIFC courts, why they should not be allowed to continue to practice when they have submitted and met, based on the cursory review of the registration process, all the relevant steps and requirements. So
well, the registrar's position on that, Mr. Morgan, as I understand it, is that that is irrelevant because the current proceeding is concerned with the fitness of the firm to remain on the register of firms entitled to represent parties before the court. And the registrar's position is that the firm is not fit because the firm supplied fraudulent documents relating to your registration in November of last year. So do you want to say anything in response to that?
I will not speak on behalf of the second defendant of the firm. They're very well qualified to speak to the merits of that allegation. However, the statement by the registrar, Madam Registrar herself, said that there is a high level of tampering. And the only closing remark, Your Honour, I will make is that I have never said that the documents requested will not be provided. They will be provided. I do not control the Secretary of State. I did not control the embassy.
I don't know, somebody must have them. You've had 3 months within which to provide the documents, Mr. Morgan, and you haven't provided any.
It takes 12 weeks, Your Honour. 12 weeks, the Secretary of State to attest. And then after 12...
You don't have to wait for the Secretary of State. You could have provided something from the courts. And the documents you've provided from the courts are all said to have been forged for various reasons, and you've provided no specific response to those allegations, have you?
I provided the response, Your Honour, that all the documents which were questioned will be attested by the appropriate government authority in Washington, D.C., which is the Secretary of State, then further notarized by the Embassy of the United Arab Emirates in Washington, D.C., and then further attested by the Ministry of Foreign Affairs. I wish to hasten that process.
Well, Mr. Morgan, isn't that just an excuse for delay in the provision of the documents? Why can't you provide original documents issued by the courts in the United States that can be subjected to evidence, assessment and analysis by the court?
For 2 reasons, Your Honour. One, I'm not seeking reinstatement. I do not seek to be reinstated within the DIFC courts. I consented to that in my very first submission in response to the registrar. I'm only submitting it to the court with the greatest respect, to ensure the integrity, not only of myself, Your Honour, but the integrity of the court, which I hold in the highest esteem. I've had the opportunity to view the court and met many when I was in Dubai, the officers of the court, and I hold them all in the highest esteem. Also, your judge, your brethren judges. So, Your Honour, as I said, I'm not seeking reinstatement. I only wish to continue the integrity. Now, whether those documents will be accepted at that time when they're available, I can make no comment to that. All I can do is say it will be provided.
Do you deny that you are imprisoned in the United States? Because your statement isn't clear on that.
Well, the document that the registrar provided, it's not even my spelling of my name, Your Honour. So
that's exactly how you provided the statement. Do you deny that you are imprisoned in the United States?
I deny the accusation that was against me, correct.
Well, do you deny that you are imprisoned in the United States?
I deny the accusation that is against me, Your Honour, because it's not complete. And without being able to completely provide substance to that allegation, then on its merits, it can't be answered.
Well, that's just not true, Mr. Morgan. It's a simple question. Have you ever been imprisoned in the United States?
When you mean imprisoned, Your Honour, you would be talking about more than 2/3 of the population who have spent 1 night in jail in an overnight drunk tank, or you're talking about a sentence of imprisonment for a felony conviction?
I just want to know if you've been imprisoned in the United States, Mr. Morgan. Can you answer that question for me?
I have never been in prison for the allegation of fraud or dishonesty as alleged by the registrar.
Well, you have been imprisoned in the United States then, have you?
Not for the allegation of the fraud or dishonesty.
Can you, Mr. Morgan, are you going to answer my question or not?
I've tried to, Your Honour, but it's not a simple yes or no answer.
You haven't. Yes, it is, Mr. Morgan. Either you've been in prison in the United States or you haven't. Are you able to answer that question or not?
So the answer to your question, Your Honour, is, are you asking have I been in prison based on a felony conviction? The answer to that question is no.
Mr. Morgan, if that's the question I wanted to ask, I would have asked it. Well, the question I asked is much more simple and admits of a simple yes or no answer. Have you ever been imprisoned in the United States?
Yes, Your Honour. I have spent overnight imprisonment in the US for drink driving on 2 different offences. All
right. Are there any other occasions upon which you've been imprisoned in the United States?
No, Your Honour, at all.
All right. Now, if you go to your statement, you say, have you got your first statement there, the statement that was filed, I think, on the 15th of December?
I have not, Your Honour. As I said, as I consented to not seek reinstatement or contest these proceedings, I have not received access to any of the online portal documents.
All right. Well, these proceedings are not just involving your registration. There's an application that you be fined as well.
So I have not seen that, Your Honour. I have not seen that, Your Honour.
Well, you are. Well, they've been provided to the email addresses, and there is an application that you be fined the maximum amount of $15,000. So you can't just turn your head on the back, turn your head to the application and say, I'm not going to deal with it because I don't want reinstatement.
Sorry, Your Honour, it's not that I don't wish to deal with it. I've just never seen it.
Well, whose fault is that, Mr. Morgan? It's been available to you. You filed a statement in the court.
Right,
you must have seen the application in order to respond to that.
No, Your Honour, I have not seen the application. I've only seen this.
But your statement is provided in. I'm reading from paragraph 1 of your statement. It's provided in response to the application by the DIFC registrar, and it deals in details with the statement made by the registrar.
I have not seen that there was a. Sorry, Your Honour.
Yeah, but you must have seen the statement made by the registrar.
I have seen the statement, but I do not recall a fine being attributable to. But again, Your Honour, if a fine is what the court is ordering based on their determination, then, Your Honour, I'm not objecting to the court's decisions, as I'm already consenting to it. If there is such a fine, Your Honour, then that's obviously at the court's discretion under the relevant code of conduct. I have reviewed Part 40, Part 41, but I have not seen a monetary fine within the code of conduct. But if that is the court's determination, then so be it. That is the court's determination. I'm not contesting it, Your Honour.
All right. Well, in paragraph 5 of your statement, I'll read it to you. It says, without the need to provide all the information surrounding the information contained in the allegation relating to the imprisonment in Utah, the time between December 29, 2009 and December 10, 2012 is less than 3 years. Certainly the DIFC court will be aware there is no parole or early release in the US federal court, so therefore this statement is completely and factually incorrect by doing a mathematical calculation. So that's on the basis of the documents before the court, which showed release on December 9, 2012. Then in paragraph 13, you say, without the need to go into a lengthy personal chronological history, the accusation is a misnomer, as you cannot be sentenced to a term of imprisonment on accusation. Furthermore, if requested, it would have been provided in a closed meeting with the registrar that on the 9th of December 2012, which is, of course, 1 day before the date upon which the documents suggest you were released, I received an exoneration from the US Department of Justice, which was given under a sealed order pursuant to very serious misconduct by the US Federal Bureau of Investigation. Now, I don't understand that. From what were you exonerated?
All charges, Your Honour. 52 indictments.
And what charges were they?
I would have to, with the permission of the court, I'd be happy to send you those indictments, but they were various financial crimes, Your Honour, nothing to do with the, how do you say, there was no allegation of fraud and no misconduct before a court or a governmental body in terms of practicing, I think, which is under Part 40, G number 3 or 4, Your Honour.
And you then go on to say the order was provided under seal and the agreement giving full exoneration was sealed by the US federal court. Now, you haven't provided any documents relating to that to this court, have you?
No, not by lack of trying, Your Honour. I have, with my understanding from Mr. Almari, there has been many attempts to contact Madam Registrar to set a meeting to resolve this. And
well, you could have provided these documents to the court in conjunction with your statement, couldn't you?
Not under seal, Your Honour. No, I cannot.
Well, why does it matter that they? Sorry, you say that because the order was provided under seal, you can't provide it. Why is that?
That was the instruction from at that time, whom representing me said, you cannot disseminate this document in the public sphere. So I have chosen not to.
But you're not disseminating into the public sphere. You are providing it to the court in response to a serious allegation of fraud.
Very serious, Your Honour, and I take it very serious. And there was many attempts to contact Madam Registrar and try to mediate this and provide the relevant alleviation of her concerns. But we were met.
Well, why didn't you provide the document, or at least a copy of the document, with your witness statement?
Because I was under instructions from my attorneys in the US at the time in 2009 that such document cannot be provided in such a manner. It
was 2012, wasn't it?
No, Your Honour. This is the problem, Your Honour. There seems to be so many dates thrown around here, there, everywhere, this date, that date. I mean, I'm being accused of some very serious and heinous allegations. And in the attempts to try to remedy this, we've been given no opportunity, Your Honor. And
Mr. Morgan, that's not right. You've been given every opportunity to address the allegations against you. They were made in early December. You responded to them on the 15th of December, and you've had almost 3 months since then in which to respond, almost exactly 3 months within which to respond. So I won't accept the proposition that you've been denied the opportunity to respond to them, because it's just not true. Now, is there anything more you want to say?
No, Your Honor. As I said, other than I consent to the removal as per the application, we have no access. I personally have no access to the online portal. However, I will request and study the application, certainly to your orders, which I presume will be commiserate to that application.
No, there's no need, Mr. I'll announce my decision at the end of the hearing today, Mr. Morgan. So there's nothing more for you to do in that regard. All right, unless there's anything else, Mr. El Murray.
Yes, I want to explain our position, Your Honor. Now, we are a firm registered in Abu Dhabi, and we supply our document to register in the DIFC court. And we got the document approved as a registered firm in Abu Dhabi court. I am the owner of the firm, and I have all the client being appointing us, who's giving power of attorney to me in person capacity. And we have different clients who we represent in the DIFC court. We don't know about the allegation, and the comments came from the registrar only recently, before one of the hearing came for one of our clients, and we got to know that Shaun Morgan is suspended 3 days before the hearing. Now, as a managing partner of the company, I enter to understand what's the requirement. We confirm, we consent, we understand that Shaun Morgan is suspended, and we want to know what the reason, and I am ready to meet. I'm ready to discuss. I have my client right. We have hearing we are prepared for. We have other clients who we represent. They said suspended. You need to provide 1, 2, 3 documents, which is before the registrar. Other colleague for Aisha, she sent an email and she gave us time frame. After that, the time frame being changed, and we not to grant to have the hearing. And I got a different call from client, what's going on. We got to know, and everybody in the DIFC court, all lawyers, all firms got to know about the suspensions of the firm and Shaun Morgan. Now, as a company or representative, as a company being registered in the DIFC court, where we never ask any document, any further clarification or documents, I have no clarity what's going on. Once I understand there is suspension related to documents, I involve myself to communicate on what document being provided by Shaun Morgan, not because what I confirm this document or I am sure about that document. What he ever forward to me, I forward to the registrar. We confirm the suspensions.
But that's precisely the point, Mr. El Murray. On the 22nd, the allegation against you, and which I haven't heard you really come to address yet, is that on the 22nd of November last year, you forwarded to the court documents relating to the certification and registration of Mr. Morgan, which were forged and fraudulent. And in a context in which you were aware that there were allegations that Mr. Morgan's documentation had been forged. And so in that context, without making due inquiry as to whether the documents were forged or fraudulent, you provided more examples of forged and fraudulent document. The registrar's position is that that conduct shows that your firm is not fit to remain on the list of firms entitled to represent parties in proceedings before the DIFC courts. Now, that's the case you have to meet, and I want to know what your answer to it is.
Yes, we already been suspended, been removed, Your Honor. Without that, now I only forward what I've been given as information. I forward to the registrar and the subject to them to check and to confirm. I am not the authority to check, verify, and to know the quality of the documents and the paperwork which came to me. I forward what is, yes.
That is precisely the point. In a context in which you knew serious questions had been raised in relation to the legitimacy of documents that had been provided in support of Mr. Morgan's registration, without making any inquiry whatsoever, it seems from what you just said, into the legitimacy of the documents you were providing. You provided documents which were fraudulent and forged. Now, that is said to be conduct which falls well short of the standards of practice of reputable legal practitioners, such that your firm should not remain on the register. Now, do you have any answer to that proposition?
Yes, I explained to you, Your Honor. I have a hearing and the document being supplied by Shaun and the same being forwarded to Registrar.
Yeah, well, you didn't do anything, even though you were aware that the allegation was that he had provided forged or fraudulent documents. You simply passed on more documents that he gave to you without checking whether they were forged or fraudulent. Is that the position?
We are not aware it's been forged, Your Honor.
You were aware that that was the allegation. You were aware that was the allegation.
We was not aware, Your Honor. It's not correct.
Right, is there anything else you want to say, Mr. O'Malley?
Yes, Your Honor. We provide different. We are confirming to remove Shaun Morgan as a practitioner on the firm. We provided different candidate to register on the firm, all being already, as the firm being already removed from the system, and we are not having access to portal. And this case also, we don't have access to portal. We don't have the document. We don't have access, and we don't deserve this treatment. We register as a firm. We pay the fee. We got this inquiry from the registrar. We confirm with the registrar, and as we see this, we are consent to remove him. And we are, if we, the court see, we are having no issue of this. What we have is a mistake from the firm. We should not deserve to be removed. We request to reinstate it, and we provide candidates, and we have clients, and we are, Your Honor, don't deserve this treatment. We requested many meetings with Aisha, and in the same day I arrived to the Judge Umar Al-Bahiri, and we got meeting with Amna Al-Uwais on the same date of the same discussion myself. After when the meeting call, we got the case being registered.
Yes,
and
right.
While I am myself interfering and coming, and I want to find a solution for this.
Well, Mr. Al-Mari, you said to me that you weren't aware that there was an allegation that Mr. Morgan's documents were forged. I'm just going to the email.
I was not aware.
Well, there's an email from you to Registrar bin Kalban dated the 22nd of November 2023. I'm sorry, an email from Registrar bin Kalban to you in which, sorry, yes, no, I need to go further down the trail. Now, on the just bear with me, on the 22nd of November, you wrote to the registrar saying, we are informed the sealed documents as required by the DIFC court registrar will be available today. We are inquiring if we need to inform Justice Michael Black. So you were aware, and the email trail reveals that Mr. Morgan had been suspended on the 17th of November because of doubts with respect to the legitimacy of the documents that he had provided in support of his registration, weren't you?
No.
Well, why did you think the sealed documents were being asked for? Mr. O'Malley?
Yes.
Why did you think you were being asked to provide the sealed documents?
May I interject, Your Honor? Just a question for clarity.
No, Mr. Morgan, you may not. I'm hearing from Mr. O'Malley at the moment. Mr.
Yes,
O'Malley,
we was not aware about the allegation about any fraud of tampering. We been asked to provide a sealed document from the court of Maryland. We
Well,
requested the same.
you were aware that Mr. Morgan had been suspended on the 17th of November, weren't you?
Yes, we confirmed that.
Why did you think he'd been suspended?
We don't know. We have no idea why he's been
After you're
suspended.
aware that you were suspended, you were asked to provide sealed documents relating to his registration, weren't you?
They ask us queries. We was not aware of why suspension decision being done.
Well, Mr. O'Murray, that I
Yes.
don't accept that. You were told that he'd been suspended, and then you were asked to provide sealed copies of the documents proving his registration. You must surely have been aware that he was suspended because there was doubts with respect to his registration in the United States, mustn't you?
No, we was not aware.
Well, that is a difficult proposition to accept, Mr. O'Murray. What else would you like to say?
I explained our position, Your Honor. We request to reinstate it, and we are confirming to remove him, and we are looking forward for your decision, Your Honor.
Mr. Morgan, is there anything else you wanted to say something then? Is there anything else you'd like to say before I go back to the registrar?
You're on mute, Shaun.
Apologies, Your Honor. No, I don't wish to add anything more. I defer to you, Your Honor. I only wish to provide clarity.
All right. Registrar, is there anything you wish to say in response?
No, Your Honor. Thank you very much.
All right. All right. Well, I've reached a view in relation to this application, and I find that on the materials before the court that the complaint is made out and the allegations of breach of the code of conduct have been established against each of the first and second defendants. I'll publish reasons for my conclusion in due course. And in the meantime, I will make orders in the following terms now. Order 1 is that the court finds for reasons to be published in due course that each of the first and second defendant have committed breaches of the mandatory code of conduct for legal practitioners in the DIFC courts, being order number 4 of 2019. 2, the first and second defendant are publicly admonished for their misconduct. 3, the first defendant is fined $15,000 US. 4, the second defendant is fined $50,000 US. 5, the first defendant shall be removed from the DIFC court's register of practitioners. 6, the second defendant shall be removed from the list of firms registered to represent parties in proceedings before the DIFC courts. Now, Registrar, there's one issue that I want to raise with you now, and that concerns the provisions of Article 39 of the code. I don't know if you have that handy.
I do, Your Honor.
Okay, now Article 39 provides that there is an entitlement to make application for permission to appeal in respect of persons found guilty of breaching Article 38. And it also provides, in a provision that I don't have to hand, it provides that if an appeal is launched, both the original decision, and appeal must be commenced within 30 days. If the appeal is launched, both the original decision and the appeal decision are to be kept confidential until the appeal is disposed of. So the question I have to you is that, and Article 39 also gives power to the Court of First Instance to make orders to the effect that the proceedings be kept confidential. If I don't make an order to keep the proceedings confidential for at least the appeal period, and there is an application for appeal, then the cat will be out of the bag. And so the purpose of Article 39 will be defeated. So what I'm asking you is, should I not make an order requiring these proceedings be kept confidential for a period of 30 days or until the final determination of an appeal from this decision?
I would say, Your Honor, in that order, we can, what we think should happen is that it should be published. However, I would say that we maintain the privacy for 30 days from the date of the order. And if an appeal is lost, then we will continue the privacy pending the determination of the appeal.
Yes, all right. Well, I think otherwise, it seems there's a bit of a flaw in the article, in the sense that if there is an appeal and the decision is published immediately, then the objective of maintaining confidentiality will be defeated. So Order 7 will be that the decision will be published in due course, but the decision shall be kept confidential for a period of 30 days or until the final determination of any appeal from this decision.
I'm grateful you're.
All right, unless there's anything else, that completes these proceedings, and I thank everybody for their assistance.